recognizes the gentleman from Wisconsin, Mr. Grothman, for his question.
Well, Dr. Sanders, I'll keep you going here. You cited in your testimony that child welfare consent decrees work against the people they're trying to help. Can you give us examples or elaborate on that a little bit?
Over the last 15 years, there have been numerous developments in brain science and in research around predictive analytics, other efforts that have resulted in improvements in the ability of government agencies to protect children. The consent decrees often lock states into agreements that were made at a point in time and don't allow the kind of flexibility that can be implemented to increase the likelihood that children will be protected. So examples would include some of the states like Tennessee that were sued more than 15 years ago and aren't able to implement some of the research changes that have occurred more recently to improve lives of children.
Let's take an example of a kid. We'll call him Joshua. Fictional kid maybe, but Joshua, a child who, how would we deal with him without the consent decree? And because of the consent decree, how are we dealing with him, hurting him?
I may take the liberty and suggest that part of the solution would be if there were an ability to modify the consent decrees more regularly based on changes in federal regulation, changes in state performance, et cetera. That doesn't happen as much as we think it should. So in Joshua's case, it's quite possible that Joshua, as a result of the consent decree, would be seen more frequently by a social worker. What might not happen is that Joshua's social worker would be better trained in trauma-informed practice, which is emerging as a way to keep children safe. And so the visits might occur, but the actual improvements in Joshua's performance and by the social worker may not occur.
Can you give me an example of, say, in Joshua's case, this is what happens to him under the consent decree, and this is what we'd be able to do differently?
So under the consent decree, we can assure that the state will send a social worker out to see Joshua. Under a consent decree, that would occur. What would not occur is that social worker may be trained in new techniques that would result in Joshua actually being safer.
Okay. In New Jersey, in 2004, because of a consent decree, the state invested billions of dollars in its child welfare program, but they still haven't been able to exit their consent decree. In March of this year, the federal judge overseeing the case called New Jersey's program a national model. If the program is really so successful, according to the federal judge, why hasn't the state been able to exit from the consent decree?
I'm not entirely sure. What I speculate based on knowing something about New Jersey is that there are measures that have not yet been achieved that were part of the initial settlement agreement, and there is a continuing need to improve on specific measures that were agreed to at the time, and that there is not 100% compliance.
Okay, Governor Engler, I think the whole problem here with consent decree is it kind of gets at our whole form of government. Okay, like it or not, every November and spring elections, people show up and vote for people who they want to have vote on our laws. The idea behind consent decrees is that this system of elections doesn't work very well, and we would be better off determining our laws when some bureaucrats and judges and lawyers get together and decide what they will be, right? So it's kind of, the whole idea is opposed to kind of our whole form of government. But can you give us some examples of consent decrees that you think were damaging to Michigan in your term as governor?
Sure. We had a federal judge. This started in 1977, but Judge Fikens, the late Judge John Fikens, was in charge of the women's prisons in Michigan, and he referred to those as his women, and he was very solicitous about what needed to be done in those prisons, and he had lots of opinions. And we had a monitor that he had appointed, and basically he was in charge of the prisons. He was setting policy and instructing us to follow that. We had another judge who was dealing with prisoners who were dealing with mental illness, and in that case, when I became governor, we were being fined, I think $25,000 a day was the suggested fine for the state because of the previous administration failing to comply with the consent decree. In both of those cases, what I found from our corrections experts, our people running the department, is that they thought having to take the temperature of the oatmeal being served or to be monitoring the temperature of the showers or a number of other reporting requirements were imposed had gone far beyond the pale. And they were arguing that you had differences in opinion, respecting different philosophies, I suppose, that of how we ought to run the system. And we even had at a point a requirement that we could only put one person in a cell, which we thought that's pretty limiting in terms of our prison capacity. The latest one, which I made the decision as governor not to enter into consent decrees. I said, look, we'll litigate these. My legal services actually are free. I've got the Attorney General to do that, so we'll fight these. And so we did not do that, but after I left, my successor entered into a consent decree, which now has run for several years. It's going to be $50 million a year is what they're saying. This one is Dwayne B. versus Granholm against the Human Services, and it was brought by a New York group called Children's Rights, Inc., a perfect example, activist, showing up and saying, this is how you ought to run it. We've already paid, I think, $6 million in attorney's fees for them. They're involved with the monitoring, and they're involved with the sort of day-to-day departmental operation. The state has been trying to modify that under Governor Snyder. They had a renegotiation of the consent decree. They end up with 211 goals that were part of the modified settlement agreement. And so they're not running these agencies when you're in that kind of situation. And your premise of the question is very important, again, it's something that Congresswoman Fox mentioned. Who decides? And I think it ought to be the men and women who get elected. And if there's a deprivation of a constitutional right, that's not been a finding in this. This is just a difference, a fight over how you ought to run this system. And I thought Dr. Sanders' testimony, one of the things he pointed out, sometimes you're mandated to spend a lot of money even on technology because that's what the masters in Washington or the agencies want. That comes maybe at the expense of training the caseworker that's dealing one-on-one with the client.
Thank you. Wish I had more time.
The gentleman's time has expired. The chair now